Good afternoon, everyone. Good afternoon. Can you hear us? It's me?
Speaker.
Oh, hello. It's testing.
Can I get the thumbs up if you hear me?
Thumbs up.
There you go.
So, it's actually my fault because I keep forgetting that I have to hit the speaker button. But and you could ask Alan though. I've come a very long way in figuring out these controls. Do you agree? Thank you. So not too bad. Anyway, we don't have a very large docket, although I have heard that it won't impact you, but they're having some trouble in North Broward getting some people in, I hear. So we'll see. But anyway, the first person is a Mackenzie Petitbois, or Boys.
What?
Oh, but didn't I say it nicely the first time?
Yes.
It sounded nice. It sounded nice both ways. Yeah.
Yeah.
I thought it did. Okay. Anyway, very simply, or not simply, but you have an out-of-state hold, so you'll have to go see the extradition. We have an extradition proceeding, which I guess will be. Is it next week? I don't know.
There's one tomorrow, but I don't know if he'll be able to make the docket tomorrow. If not, it should be next week. I think Tuesdays and Thursdays.
Tuesdays and Thursdays. Thank you, madam. All right, sure, of course. And then I have Angela Clark.
Ms. Clark is here present at Maine. Come on up, Ms. Clark.
Oh, fantastic.
She declined the services of public defense.
So noted. Good afternoon, ma'am. Hi.
Hi, how are you?
I'm good, thank you. And you've been arrested on two counts, one for possession of cannabis, one for possession of drug paraphernalia. And I did find probable cause, and you do have a bond. And your bond is currently set at $100, and you have a choice. You can choose to bond out, or if you wanted me to extend an offer of sentence to you to resolve your case today, I can do that as well.
Okay.
So if you wanted to enter a plea of no contest today, the offer of sentence would be what's called a withholding of adjudication, no adjudication, no conviction. I'd assess court costs in the amount of $308, and I'll give you extended time to pay. Or you can choose to challenge your charge and bond out, and the bond is currently $100.
Okay, I have that.
You want to bond out?
I have that on me.
Oh.
No.
Okay. Then that means you'll be bonding out, and then the case will remain open, correct?
Okay.
Is that what you want? I don't want you to be passive. I want you to tell me what you want to do.
Can you repeat the other option?
Of course.
First, please?
Of
Thank you so
course. So let's start from the beginning. You have two choices, essentially. If you wanted to bond out, post a bond, and then return to court to challenge your charge, which is your fundamental right, then you'll be bonding out. If you say, Judge, I heard the offer of sentence of a withholding of adjudication, which is not a formal conviction or adjudication, and I choose to accept that, then that's called a plea of no contest, and the case will be over. So those are essentially your two choices: bond out and challenge your charge, which you could still ultimately resolve by plea if you so choose, or resolve it today.
I guess I will resolve it today.
That was a little more affirmative. So you want to enter a plea of no contest today? Yes?
Yes, ma'am.
Okay, fine. And so that'll be the withholding of adjudication on both counts, court costs on one count, and I'll give you, is 90 days enough to pay $308? Do you need more time?
Pay how much?
$308 in court costs? 90 days, or do you need more time?
And then if I get out to
What? Are you sure you don't want to talk to the public defender?
I guess I should have a public defender and not just be by myself.
Good idea. Good idea. Sure. Why don't I let you all consult? It's confusing. Hello. Do you mind putting your phone away? Thank you.
Judge, respectfully, she's not gonna resolve her case. This is her only charge, to put a drug charge on an 18-year-old. She's gonna try and go to court. I believe she'll be
That's
eligible
fine.
for.
I'm not telling her to do anything. She can
Exactly.
bond out. Thank you very much.
Thank you very much, Judge.
Sure. And Hannah Binyamin. Oh, thank you very much. She bonded, or he bonded. I'm sorry, I don't know. And Barbara Hightower.
North Broward.
Okay, let's see what's happening in North.
I didn't show it.
Has anybody at North?
Right here, Your Honor.
Oh, is everything going well at North?
All is well, thank you.
Oh, good, good.
Good
And
morning, Your Honor.
hi, Miss Hightower. How are you today?
I could be better.
Of course, I understand. And this is for one count of possession of cocaine, one count of possession of controlled substance without a prescription, and I did find probable cause, and on both. And you do have a bond. The bond is currently set at $1,000. Are you able to make a bond?
No, I'm not, Your Honor. I have no
That
money.
she's not able to make the bond.
You have a place to live?
Yes, I do.
She had been living at her previous residence for 6 years.
Okay, so
She's been a resident of Florida since the year 2000. She's not working because she has a disability. She's a former social worker, or she has a degree in social work. She used to work in the Palm Beach County Circuit Court as a family court mediator. She did that job for 10 years. I would ask, she also says that there is a prescription for count 2,
Yes.
which hopefully we can produce at some future date. I'd ask the court to consider pretrial release.
you know, I am going to consider a pretrial release, and I am also, however,
Excuse me, Your Honor, excuse me.
just a substance abuse screening. So you live in the city of Pembroke Pines?
Yes, I do, Your Honor.
Yes, and I would like her to go for a substance abuse assessment and screen.
We had discussed that. She's
Sure.
agreeable to that.
That would always be good, because if you also, and you being a social worker, I don't have to tell you about the behavioral health
Absolutely.
issues, correct? And if there is
Correct,
any,
Your Honor.
and if there is any co-occurring underlying depression, then you're gonna know it. And what is that saying? It's like the shoemaker's kids have no shoe. When you know, and then everybody else is the one that gets helped. And you know.
Absolutely.
Right. So let me tell you, social workers are amazing. So, all right, thank you very much. You're going to be released.
Okay, thank you so much, Your Honor.
Sure. All right. And Darius Garcia?
Ms. Garcia is here present, Judge. My understanding is she contacted her daughter. She believes her bond may have been posted. Is there any way to confinement status to verify that?
Sure. Not posted as of yet.
Judge, in my reading of this probable cause affidavit, I have some difficulty tying Miss Garcia into the narcotics that were in the possession of Miss Hightower.
Right. Well, Miss Hightower.
Weren't they arrested together?
Oh, I didn't think that.
Yes, they were. It says here, according to the report, that Miss Garcia stated she wasn't familiar with the area, that she was just
yes.
there because she heard they do good body work. And then it was Miss Hightower who said, you know, I have cocaine. She had the cocaine in her, I guess, in her bra. And then the other narcotics were found really, it seems, in Miss Hightower's possession and pills in her purse. But there's no indication that Miss Garcia was in possession of any narcotics or would necessarily have had any knowledge that narcotics were present.
Second paragraph, third page. The passenger, Darius Garcia, then stated she had some cocaine which was located in her right breast area under her blouse.
Oh, I thought that was Miss Hightower who said that. Okay, I see it. I see
Right.
it.
Well, same fact pattern, same finding.
Judge, the only thing I'd point out at this time, I believe this was a consensual encounter. Law enforcement approached them, and basically Miss Garcia on her own, was cooperative with the law enforcement, told them everything like that. I believe this is her first arrest ever.
Just tell me what you're asking for. You don't need all this predicate.
In ROR.
Okay, I'm happy to put her on pretrial release under the same conditions as Miss Hightower. If she's interested, or she could wait to bond out.
Let me ask her, Judge. Thank you.
Just ask me. Tell me what you want. Oh, did you want me to?
I'm
Yeah.
just holding off.
Sure.
Peradventure, I'm not sure.
There you go.
Judge, respectfully, she's gonna bond out.
Sure, thank you.
Now,
Thank
we're
you.
right across the water.
Yes, of course. Oh, Christopher Plummer. That's a famous
Good morning,
name.
Your Honor. No problem.
North Broward.
Oh, thank you. Thank you.
I'd like to resolve this if
Hi,
possible,
Mr.
Judge.
Plummer.
Good morning.
Oh, I don't. What do you mean resolve? What do you mean?
Well, it's a misdemeanor.
Oh, I don't know. Okay. Just for the record, you have been arrested on one count of carrying an electric weapon or device, essentially carrying a concealed weapon. Priors, please.
Thank you, Father. Please.
As far as Broward, he had some burglary dwellings, but they're dated. His last Broward prior was 2001. Anything very serious? He's had some priors out of Fort Myers. What was the most recent?
I'm really more interested in a national view.
Sure. DOC. Yeah, I'm not seeing anything since his, what was it in Fort Myers in 2011? Leak.
No.
Yeah, this is
Hold on,
trespass in
Mr.
Fort
Plummer.
Myers with a criminal mischief
sir.
in 2011. His more serious stuff was about 17 years ago.
You have a place to live or you do not?
Yes, ma'am, I do, ma'am. Can you hear me, Your Honor?
I hear you.
Yes, ma'am, I do.
So, what do
Judge,
you,
he's been living in this.
tell me about him.
He's been living in the same location for 2 years. He also helps his disabled mother, and he works. He cleans. He holds flyers for money. He cooks. He paints. He keeps himself busy working, is what he indicated to me. And he's been a resident of Florida for all of his life, and he does have brothers and sisters here in addition to his mother.
I'll offer him withholding of adjudication, 6 months probation, no new criminal offenses. He doesn't have to take it. I'm just telling you what I've got some concerns about this, so I'm just sharing that with you. Had a knife, according to the allegations, in his waistband. You know, while panhandling for money. I'm not asking for comment. I don't want him waiving any of his rights.
I understand.
I'm just letting you know I have concern. That's all. So if he wants to try to bond out, he can do that. If he, wants to accept the offer, he can do that. If he wants to go on pretrial release, he can do that. But he's still going to be monitor. Monitor.
The judge would let you out on pretrial release, or you can have your mom bond you out. I'll give your mom a call.
May I ask what is pre-child release, Your Honor?
Sure. It means exactly the way it sounds, that I would release you on a pretrial basis. You'll be under the supervision of Broward Sheriff's Office Pretrial Release Office, and you'll have to report by phone, then they'll double check to make sure there's no new criminal offenses as you go through
Yes, ma'am.
your criminal justice process, assuming that the case even gets filed upon, this is just an arrest phase.
I'll take the offer, Your Honor, and I appreciate your offer. I would never turn it down. Thank you.
Which offer was that?
You said
the pretrial release offer?
Yes, ma'am. I get released today,
You will
Your
get
Honor.
yes. If there's
Yes,
nothing
ma'am.
else holding you, you will get released, and then within 24 hours of your release, you need to report to the pretrial release office.
No problem. No
Good.
problem.
No weapons of any
No
kind.
weapons. Nothing. Yes.
Sounds
Yes,
like
ma'am.
you sound like a good bet.
Thank you, ma'am.
You do. I'm letting you know. I
Yes.
feel a little better. Thank you.
Thank you.
You're welcome.
Thank you.
Bye. Sometimes a little dialoguing is not a bad thing. I've learned that through mental health. Court and mental health.
We have Mr. Lamont Green right here, Judge.
Yes, and this, Mr. Green, sir, this is for one count. You've been arrested for one count of trespass, and if you wanted to resolve your case today, you certainly can. And the offer of sentence would be a withholding of adjudication. And they really, apparently, you've been trespassed. So the probable cause affidavit says from that particular bus terminal. Doesn't mean you can't take a bus, but you're going to have to try to find a different bus terminal, or else you're running the risk of potentially being arrested, correct?
Okay. Okay.
Okay,
I'm going to resolve my case today.
done. Thank you. So withhold, thank you. Withhold on Green. And you can convert any costs for him. Oh, I'm just gonna push, I don't even know what some of that paperwork is, though. I might be making notes, There you go. Okay, I have Damari Phillip.
Yes, ma'am.
Hi, good afternoon. And sir, give me 1 second. This is a trespass.
Your Honor,
Yes, sir.
just to advise the court, I'm just looking at the original NTA. This involves someone's home where allegedly,
Yeah, I was gonna say, I don't have an affidavit.
yeah, no, that's why I wanted to advise the court. Allegedly, Mr. Phillip was sleeping in front of, on the front doorstep in front of the owner's home. She said, according to this, one moment. She was afraid to walk out of her door. Law enforcement came, issued a trespass warning, and Mr. Phillip returned 20 minutes later.
Oh. What city is this allegedly?
This was in Lauderhill.
Judge, I believe that, from what I read on the NTA, it was an apartment complex. He was, from what I found out, he's homeless. He didn't return to that specific location, the front step of her apartment doorway. She just returned to the complex, and that's when I believe he was taken into custody. However, at this time, he did find a friend that he's been staying with him for about 2 weeks now. Her name is Stacy. She's helping him out, but he doesn't know her phone number or the actual address of her apartment. He knows how to get there. So this time he's asking me, Your Honor, if you would consider resolving his case for time served, or in the alternative, releasing him to standard pretrial. He'll be released within 24 hours of his release. He'll get the address of his friend and provide the address to pretrial.
Any priors?
I'm checking that right now.
Let me just kind of take a wider look at this.
Yes, Judge.
Okay, okay, I'm showing. In 2015, a woman, it's not the person whose home was involved in this matter, a woman obtained an injunction order of protection against Mr. Phillip.
So, is he receiving any mental health care in the community? Is he with Henderson?
Yes, ma'am. That's what it was.
Don't talk about the facts.
I was just saying I'm new to some. I'm just new to mental
Well,
health.
then
bro.
why don't we go into mental health and talk about it where we can kind of unravel some of this stuff? I have mental health court tomorrow.
No, I'm okay. I'm okay. I was just going through.
Look, I'm not going to resolve the case. I can tell you right now, I'm not comfortable. I'm really not comfortable between the injunction and this. I'm just not comfortable from a public safety vantage point, and
No, the injunction that was
I don't-
with an ex. That was with an ex, and that's 3.5 years ago. There's no issues with that, man. It's just only thing I haven't spoken. That's my baby's mother. I haven't spoken to her, and she was supposed to take that away from me, but we haven't spoken in a while. Just I just not just not really too much in touch with people. I've been trying to work on my issues and get myself together. That's all. Just trespassing. I was just asleep, just real tired, with nowhere to go at the time. That's all. I wouldn't do anything.
yeah, but
like
I
that
could
again.
help. But I could help you.
Let me explain. Can I explain to what the court, I believe, is trying to say?
Yeah, I'm just only saying, and
Thank you, Judge.
otherwise he's just going to be back.
Judge, respectfully, wait. I believe, yes, he would want to go ahead and appear before you tomorrow.
Fine, maybe we'll still resolve it tomorrow. But I don't have any really sense of confidence. Okay.
So
See you
he'll
tomorrow. Can you call Joanne for me, please? Madam Clerk, can you call my office and ask Joanne, please, to put this defendant on the mental health docket, please?
You didn't have to go back there. It's not. Let's say this is
Thank you. And Damari Phillip, is that who I just did? Oh, okay. Kenneth Banks.
North Broward.
He's a medical research, Your Honor.
Okay, so thanks.
Thank you.
And Michael Rich?
Here, present, Judge?
Ma'am.
Me?
Nate. Thank you. This is an outstanding warrant on, it looks like a prostitution charge, or is that right?
I think it's a municipal ordinance, and yes.
Sir, there's a $250 bond on a capias. Could I make an offer on that?
It's a municipal ordinance, Judge. It's your
Were
call.
were you interested in resolving it? Did you want a lawyer? What do you want to do?
Let's get it resolved today.
Okay,
It's resolved.
okay. The offer of sentences, are there priors or? One second, please.
Yes, Judge. I mean, aside from a Grand Theft Auto last year, His most recent priors in the past few years have all been trespasses.
Your offer of sentence is a withholding of adjudication, no adjudication. The HIV blood, STD blood screens, not the results. Those are private to you, but the statute requires, because this is kind of like a public health kind of oriented offense. So the statute requires that within 60 days and court costs, and I'll give you 6 months to pay your court costs. So a withholding of adjudication, the proof, just proof you had them, not the results. Those are private patient information. And then the court costs, and I'll give you extended time to pay.
Yes, ma'am.
Okay, you're all set. Thank you very much. I'll find it back to business. How much are the costs on that? Like 12 months?
See if you recall the message.
And Kurt Anderson.
Mr. Anderson is approaching, Judge. He's here at me.
Thank you. Mr. Anderson, sir, you have been arrested on 1 count of resisting or obstructing without violence, driving while license suspended or revoked, and possession of cannabis. I think that's a misdemeanor. Give me 1 second, I have to clarify. And possession of cannabis misdemeanor. And I did find probable cause on all counts. You also have a number of outstanding KPSs out of Judge McCarthy's division, and I believe that's all one case. So you'll have to see Judge McCarthy. And with regards to the, just all I'm at, there's $100 bond on 1 count, the resisting or obstructing.
Thank you, Judge.
All right, thank you. Maurice Montoya.
I've been informed he bonded, Judge.
Thank you. And then Travis Cook.
I've been informed he bonded, Judge.
Good. And Sharon Henry.
I've been informed he bonded, Judge.
Looks like the afternoon people have more time to post bonds.
Yes.
With Mr. Henry, I believe that was the last gentleman here at Maine. May I be excused?
Of course. Thank you.
Thank you, Judge.
We'll see you tomorrow. Bye.
Thank you.
Oh, wait. No, let him go. Let him go. We've only got one more. And then Mario Felizor or Felizor.
North Broward, Judge.
Oh, thank you.
John, we had a problem in that particular housing unit, so can you put him on a brief recall?
Sure.
Still trying to get him in.
How much time should I come back? I mean, not
About 10
come.
minutes.
I mean, check in.
About 10 minutes. About
Okay.
10 minutes.
Just call me when you get him.
Oh,
Okay, thank you.
thank you. Of with Giorgiani? Got it. Okay. I'm looking for Billy Cross. Billy Cross. Anywhere?
No crowd, John.
Oh. Okay. Hello.
Hello, Billy Cross.
Thank you, sir. Do you want to start us out, Aaron?
Your Honor, this is, this is a second look on a battery. He's currently being, held on $1,000 bond. I'm just looking over the PC.
Yeah, but I can't make any offers on a battery.
No, it's just, I guess in this instance, it would be for bond review. I'll print out the PC for you, Your Honor.
Can I just make a comment, please? You know, I really would not do anything on a battery, even a bond reduction without victim input or contact
And
because
you'll
of
see,
constitutional rights.
this is even, these allegations are a little bit more unusual, Your Honor, just to cover our bases.
Well, I'm not going to do anything. I'm just
No, I
letting you
know, I'm not asking you to, I just wanted you to be,
Okay, you know, I've said, huh? No. That's not exactly our target scope in a misdemeanor mental health court.
oh,
Am I allowed to speak?
I wouldn't talk about anything with regards to the facts. This case is in whose division? Is it a misdemeanor or felony?
At this point in time, it's a misdemeanor, and it has been assigned to Judge Solomon.
Okay, and what has it been filed on?
No, he was just arrested on the 20th. He came through over the weekend
I see.
before
I
Judge
see.
Bidwell.
Give me 1 second. And the criminal history?
One moment. Yeah, and I'm just reading over some notes from over the weekend. Judge Bidwell obviously was concerned about the allegations, and I guess there was a request made just in an abundance of caution. He's homeless, so pre-trial obviously was not able to verify any ties to the community. As far as his criminal history, trespass 2016, 05 burglary and 1 count of battery, failure to leave property 03, trespass 03. There could be additional priors from other counties or states, but I don't have that in front of me at this moment.
Well, again, you know, it's scanned. You know, I'm not really, again, nature of the offense, battery, victims' rights, etc. I don't have to go through the litany, but there's nothing I'm going to do on this case.
I understand.
Okay, except appoint counsel. Is the public defender's office appointed?
Yeah, I'm looking at that right.
Do you have a lawyer? Do you know if the public defender's office was appointed, sir?
I let public defender, yes, I did.
Okay.
It does look that way, too.
Okay, good. That's good. I don't know what else to say, counsel. Maybe somebody needs to go see him in the jail.
It looks as though somebody saw him today.
Okay.
I signed on Tuesday, 23, let public defender say that I was innocent, didn't do whatever they were accusing me of.
Okay.
To let me explain my position, that I was just one person, couldn't do that, whatever they said they did.
Don't discuss the facts of the case, Mr. Cross.
All right. Well, you're all set, and you know, the case is just in processing. Thank you.
I don't understand processing.
Yeah, the case is being processed. Whether it'll be filed or not filed is up to the state attorney's office. All right, so they'll put you on another docket.
Wait for the same plaintiff defendant?
I couldn't hear what you said.
So wait for the same plaintiff defendant?
No, I'm just simply saying that the state attorney's office is still looking at this case. And they're gonna determine whether or not to file charges. They may not file charges. I don't know yet. Alrighty?
Was it about 3 days?
Hang in there. I'm not exactly sure how long. All right?
Okay.
Thank you. Anthony Green.
No problem.
With victim's consent. Hello?
Hello.
Yeah, Your Honor,
Sir.
Mr. Cross was arrested for, he was arrested on the 7th originally for theft and
Do you mean Mr. Green?
yes, sorry, Mr. Green, for theft and a violation of probation hold on a grand theft auto. I'm showing that he has resolved the violation of probation. He's county sentenced and scheduled for release next Wednesday on the 31st.
Okay, so the only thing left is the petty theft?
Yes, and I reviewed that the allegations are at Publix on Coconut Creek Parkway and Coconut Creek.
Okay, so did you want to resolve the petty theft?
Yeah.
You can resolve the petty theft. I'd offer you a withholding of adjudication, and don't go back to that Publix on Coconut Creek.
Okay.
And the property was recovered, there's no restitution issues.
Easy enough. All right, thank you very much. Good luck. Anybody ready?
No problem?
Sure, we're here.
Okay, I have Mr. Felazor.
Oh, good. Thank you. That was quick. Hello.
Hi.
Okay, now you might have to a little bit of assistance. Sure. Sir, this is an, count 1, aggravated battery with a deadly weapon. Is that accurate?
Yes, Your Honor. Do you have to? He's in part, or you don't, fellas, or the F.
1 second, please. And just for the record, I did find probable cause, and
I'm just checking to see if he has any record. It's not a change of charge. All right, if I could just have a moment, Your Honor.
what, Kaish?
Yeah, I'm just. And they ran a full. Okay. Yeah. So it appears he has no criminal history, Your Honor. However, I do have concerns based on the allegations and the level of violence alleged in the reports that have been provided. Your Honor, State would be requesting a $10,000 bond in order of no victim contact with. Clarence Haggard.
Just because Mr. Felazor was, they had a little trouble bringing him down, I haven't had a chance to talk to him. So I can't talk about his ties to the community or anything like that. Give me a minute, let me call up there.
Sure. Oh, I'm not quite ready.
You know, he's on the phone with.
Not yet. I'm sorry,
Yeah.
but I need him.
No, he's just off to the side on the
No,
phone. No,
somebody
I
was-
know. I just meant that they didn't send him back or anything. He's just.
All right, counsel.
Yes, Judge, I spoke with Mr. Felazor. He's been a resident of South Florida his entire life. He has an extensive family here. He works at Winn-Dixie in the produce department. He's had that job for a few months. He has been living at the same residence with his mother for the last 8 years. As the state's indicator, his prior record doesn't seem to be too terrible. He's even able to provide me with the name of his sister to contact for possibly posting bond, but he doesn't think his family is going to be able to come up with an awful lot of money. He certainly has no problem with an order staying away from the alleged victim in the case. I think the weapon here, is it a tree branch? Did I read that correctly?
Thought it was.
And I think that's what it said.
I think there's varied, according to the affidavit, potentially, depending on your interpretation, there's varied weapons, which could even include a vehicle.
And that's why I'm pulling the information to see what's alleged. No, the allegation of the information is that the motor vehicle was used as a weapon.
Is what was used?
The motor vehicle, his car.
Oh, the motor vehicle, okay. But he would have no problem staying away from her, Judge. I'd ask the court to consider pretrial release with maybe even a monitor to make sure that everybody knows where he is and he doesn't have any contact with her.
And Your Honor, and just for clarification, and that's why I checked the information. Clarence Hargret is the listed victim in this case, so the no victim contact would involve him and not the woman who's mentioned in the report, who is. I don't have.
Oh, I see what you're saying, okay.
Yeah, it's would not include
Who
Ms.
is
Walker. The information that was filed, the charge Clarence Hargret is the listed victim. For whatever reasons, we did not. I wasn't involved in the case filing, obviously, but there was no charges involving Jada Walker as an alleged victim. So,
And I guess according to the affidavit's narrative, according to Mr. Hargret, Mr. Felazor attempted to strike his vehicle head on. And there was some contact. It also seems to indicate that Mr. Walker advised he did not want to press charges. I don't know if that's a typo or what, but
Ms. Walker's not the listed victim, so that.
well, it says Haggard and Walker advised they do not want to press charges.
And I can advise you that, for instance, I have another report where Mr. Hargret contacted us, gave it some consideration, and he did want to prosecute. It's not really relevant to the allegations of the case, so it's not one of the reports I printed out. I mean, obviously,
I'll set bond at $7,500. I'd order him on pretrial release in the event that he bonds out. Absolutely no contact, direct, indirect, with the alleged victim in this case. Do you know where this person? I mean, this was a. I don't know. You know, pretrial's asking for GPS. I'll put GPS. I'm not sure of what of a location or.
I can, checking to see if,
Or do you want a level 2?
well, if
he
the
works,
court's
I
gonna
know
put
he
on
works.
if the court is going to impose GPS, I have no objection to level 2.
So in other words, you can work, you go to medical appointments, you can go to, religious events, your religious affairs until, maybe depending upon what happens with this case and if it does get filed, of course, that the judge could modify anything.
And I will provide a pretrial with the copy of the report with the alleged victim's address and phone number so they can contact him.
Okay. So no contact, direct or indirect,
It's just one.
with the alleged victim in this case. For now, it'll be GPS,
Clearance.
level 2. I'll waive the cost of the GPS.
Thank you, Patrice.
All right, good luck. Thank you.
Oh, I'll call your sister.
Okay.
Anybody else?
Yeah, I think the next case we have is, well, I guess whoever walked up.
Conti has, yes, sir.
Moses
Robert
Robert?
Moses.
Oh, thank you. 1 second,
yes.
please. Here you go. Okay, I'm listening.
Yeah, I'm just checking. Okay, here's the situation. Mr. Moses was arrested on the 20th on a resisting without violence. At that time, their law enforcement noticed he has a out-of-state hold on him out of the state of Maine. No bond for robbery, theft, and aggravated assault. Frankly, I don't know what's going on with that case. For instance, is it a new offense? Is he on probation where resolving this could have consequences? So I don't know, Mr. Reed, did you have a chance to speak to him?
No, I didn't. Again, there was some hiccup up in the jail,
I
but
don't know anything about it. I never was arrested or convicted of anything in regards to this case. I had just gotten off work. I plead.
don't discuss the
jury
facts of the
release.
don't discuss the facts of the case, Robert. Hang on just 1 second.
Well, I think that, I don't want you to comment, but I just wanted to clarify that I think what the state attorney and the public defender's office were cross-talking about is simply related to whatever's happening out of state. And that it's difficult for councils necessarily to even move forward not knowing more information about whatever's happening. Did you say it was in Maine?
Yeah, it's in Maine. I mean,
So, because everything has an implication to everything else, potentially, so it seems like there's a need to gather, maybe the public defender's office to gather more information in terms of to be able to guide you. Is that fair?
I think that's a fair statement, Judge. I'm just looking at it here on one of the sheriff's websites. I know I'd looked at it earlier, but I honestly forgot what it said. Yeah, it doesn't say much. It just says it's an out-of-state hold. It doesn't say, as Mr. Lender mentioned, it doesn't say if it's a parole violation, a probation violation, a new charge.
Yes,
It just,
I need to go and take care of it, Your Honor, please, as soon as possible. That's my intention.
Right.
I need to take care of this.
do you understand though, Robert, if you resolve this case here today, which I think we probably would be able to do, that when you get back, if this is a parole violation or a violation of probation, they could use the conviction on this charge to violate you. You understand that?
I understand.
You still want to take care of this and get back to Maine and resolve this?
cousins.
No, I mean, Maine will come and get you once this is resolved.
I'm pretty confident they'll come and get you. On a,
Yeah, no, Broward Sheriff's Office, I believe, just on experience, has already contacted Maine. They would have, if Maine had no interest, they would have dropped the hold by now.
okay.
Right. So if you resolve this case today, Maine will come and get you, and you can go back to Maine and resolve whatever this matter is. But understand again that if you resolve this case here today, it's something, bless you, something that could be used against you later when you get back to Maine. Do you understand that? I mean, I don't know what the nature of the allegations are. I don't know whether it's probation, parole, a new case. I don't want to know right now. But I just want to make sure you understand that this could possibly be used against you.
And, Your Honor, just so I can advise the court, he's scheduled for an extradition hearing tomorrow morning before Judge Dennis Bailey. So a lot of the issues that Mr. Reedy is referring to will be clarified tomorrow morning about, what's going on with the case in Maine.
But this case will still be open,
Yeah, I was just advising the court and Mr. Moses, Mr. Reedy that.
so he won't be prepared to go, even though he gets information tomorrow if this case is over.
Well, no. The clock won't start ticking until this case is ultimately resolved one way or another.
What's the allegations of this case?
Your
It's
Honor.
tensing his arms and
Yes,
pulling away.
But what was the allegation?
The allegation, they got
Nature
it.
of the stop.
They got a hit on his tag for the warrant out of Maine. Conducted the stop while the officer was placing him under arrest for the warrant.
Got
he
it. It was
tensing,
really about
allegedly.
it's everything about the warrant.
Yes.
I see. Well, it's up to him. If you want to resolve it, the offers of withholding of adjudication, no adjudication on the resisting. That's the most nominal offer of sentence that we have under the laws of the state of Florida. Then this case will be resolved, and then you can move forward to consider going back to Maine through extradition process. If you don't want to, there's no rush to do that. You can, talk to counsel further about it and make a more informed decision if you want. That's up to you.
Well, Your Honor, I know for a fact that it isn't a parole violation or a probation violation because I have never been convicted of this crime or gone to court about it.
Okay.
All right.
So then you know that.
So I feel that.
You feel
I
confident.
want to take your advice.
I'm not giving advice.
I mean, I want to
just
trust,
for the
I
record.
want to trust what you
But
have
I
to
want
say.
to. But I think what we are giving you, which I understand, you're calling it advice. We would probably be calling it information, process information.
And I'm just, so if this case is pled out, there's some finality. I just want Mr. Moses, and this is Eric Linder at the State Attorney's Office. I want Mr. Moses to be advised. If he resolves this case, nobody in this courtroom knows what effect it could have on the pending case in Maine.
That is a correct statement. It might not have any effect. It might have a detrimental effect.
We just don't know.
Well, I've served 5 days. I cooperated with the police in every way possible. Your Honor, please hear me out.
The offer is no conviction in time served.
Okay, well then.
Is that what you want to do?
Yes, sir. I
Okay.
just don't want it on my record so I can get a job later.
Well, it is going to be on your record as a withholding of adjudication. It is actually the name, the proper name of a sentence. It's not dismissed.
Yeah.
It's not, it's a withholding of adjudication. It's not a formal adjudication. It's not a formal conviction, but it is actually a form of a sentence under Florida law.
But I wasn't convicted of a crime.
You're not
in
convicted.
the process.
You're not convicted of a crime, but if you enter a plea this afternoon, in exchange for that plea, the offer of sentence is a withholding of adjudication. If anybody says, were you convicted of this? No, you were not. Is it on your record as a withhold of adjudication? Yes, it is.
Okay, so I just want everything to look good for me so that I can clear everything up when I get to Maine. What you're saying is that I'll get time served and get this dismissed.
No. You're saying dismissed, and I'm saying the offer of sentence is a withholding of adjudication. You have not heard me use the word dismissed, have you?
No, ma'am. I'm not super savvy on law
Okay,
talk.
but it's important language. Language really counts here. A dismissal means how it sounds. It's dismissed. The case would not be dismissed. It would be a withholding of adjudication. And if that's the most nominal offer of sentence I have at my disposal within my authority.
Most nominal meaning the least possible sentence you could receive is what you're being offered.
Which is just, it's done, I served my time.
Right. And you're not convicted.
Could you say it again? I'm sorry.
Sure. It has a name, and it's called a withholding of an adjudication.
Okay.
So it's up to you. I mean, I can't really explain it any better.
Well, I want to be set free to take care of things with Maine here, and they can't come and get me. You're saying
as long as you're making an informed decision, as informed as it can be. Nobody has a crystal ball. You don't have a crystal ball. We don't have a crystal ball. But it's your case, not ours. So that's the difference. You want to take it and go. That's the offer. And there is no other better offer I could make for you.
Okay. Well, thank you for making a good offer for me, ma'am. I'm real grateful for that. Do you know how long they have to come get me? And
that's going to be fully explained.
So I can get a lawyer and take care of this in a real professional way.
Yeah, but that's not going to happen because you've got a hold. So you can see a lawyer. The lawyer could come and visit you.
Judge, I'm kind of getting to the point of feeling maybe Mr. Moses should wait until he goes to extradition court tomorrow, where Judge Bailey can explain everything to him
I
in
concur.
maybe greater detail, face to face, in person, instead of on a television screen. And if he wants to resolve the case after that,
bring him back.
We'll bring him back.
All right.
Well, I want to get things moving here. I don't want to wait another week.
I know, but you're kind of vacillating. You're vacillating. And when you vacillate, it doesn't give me a lot of confidence that you're making a knowing decision, a knowing, voluntary, intelligent decision, which under the law, I have to be confident that when somebody's entering a plea, they really want to. You're vacillating. Going back, going forth, going back, going forth. I can't accept a plea like that. I can't. I can't.
I need to move forward, though, man. Your Honor, please hear me. I'm not.
I am listening to you. You're not sure, and I'm not going to take a plea if somebody's not sure. That's all I'm saying.
Well, you have communicated to me that this plea sets me free to move forward tomorrow, which is what I want to do. I want to get on with my life. I need to go to work and stuff.
It's fine. As long as that's fine. I'm good with that. As long as you understand what you're pleading to, and you're pleading to a withholding of adjudication.
Mr. Moses, you're not going to be going anywhere right away anyhow. I still think it's best if you go in front of the extradition judge tomorrow, get all the information you possibly can about your extradition situation explained to you tomorrow. Maybe the court would consider resetting Mr. Moses for maybe tomorrow afternoon.
I really don't know if he's going to get into extradition tomorrow. He is. He's scheduled. And if you want to bring him back, you can bring him back.
Maybe how about if we bring you back tomorrow afternoon, Mr. Moses? You won't be going anywhere anyway. And that way, tomorrow morning, you can have a conversation with the lawyer in the extradition courtroom and have a conversation with Judge Bailey about your situation. If you decide after that resolving this case to what's been offered is in your best interest, we'll have you back here tomorrow afternoon. And if you come back here tomorrow afternoon and you say, look, I'm not going to resolve it, then you don't resolve it. But right now, it seems to me as though you're really not sure what to do. I'm not all that comfortable as your attorney right now saying that you should do this because you're going back and forth on it. And we don't want you to come back later on, thinking, hey, I made the wrong decision. So you have nothing to lose by going to extradition court tomorrow and coming back tomorrow afternoon.
you guys clarifying that. And
All right, we'll see you tomorrow.
okay, have a good night.
Thanks. Okay, what else? What else? Eric?
Ramdeen Edson?
Oh, hello. You're Mr. Edson?
Yeah.
Yes, ma'am.
Yeah, Your Honor, Mr. Ramdeen was arrested on. Okay. On the 20th, he came before Judge Bidwell over the weekend on a battery. Judge Bidwell kept his bond at $1,000. The issues that Judge Bidwell had, well, first I would note, according to the report, Mr. Ramdeen and the alleged victim are neighbors. You've got apartment 238 and apartment 240. From the notes I have, I see that some of the issues Judge Bidwell had were, one, that at the time pretrial release was unable to verify any ties to the community. Apparently there was some type of past immigration issue or past deportation order or warrant. It wasn't clear if there was even an active issue or if it was just a prior issue. So that's why part of the reason why we are here today.
I have the same comment, that I had prior. I mean, these cases really require certain, communication diligence under the Constitution, and this is a significant phase.
And I don't disagree, and also.
So I just don't, I'm just following the law.
And even more so, and I'm not saying it would make a difference, but I think even more so, this is a situation where the parties are not strangers to one another. They clearly know each other, and I think it's even more of a reason.
Okay. So I think essentially from the court's vantage point, it's really should have really not been put on the docket. I still think that these cases are not appropriate for this docket. Right. Thank you, sir.
Okay. Copy, Your Honor.
Thank you.
Do we?
O'Neill.
Huh? Yes. Well said. Well said. Hello. Are you Mr. O'Neill?
Yes, ma'am.
Okay.
Okay. The issue here, and I'm trying to find the report. The issue that let me pull the case up first. Okay, Mr. O'Neill was arrested for a resisting without violence on the 20th. I believe he's got a $100 bond. The case is actually assigned to your MT division, Your Honor. Judge Bidwell's concerns were Mr. O'Neill was arrested December 1st of this year. He was being held a new offense of possession of PVP. He also had capiases for possession of PVP, methamphetamine, and resisting without violence.
So is that PvP case over?
No, well, one of them is. He pled out the charges he was being held on, the PVP, methamphetamine, and resisting without violence. He pled out to time served. The possession of PVP, the new possession of PVP, he appeared before Judge Lazarus Friday afternoon, the 19th, on a motion for release by the Public Defender's Office, which was granted, and he was released on Friday. Judge Bidwell's concern, it was twofold. One, he had a concern that the day after he was released on those offenses, he got picked up, and then also he had concerns that he didn't know if resolving this case, what effects it could have on the open possession of PVP case. I'm just relaying,
First of all, the larger issue, if there is a larger issue, really has to do with flocka. And that is it's lethal. And I'm not saying you consume flocka. I'm just saying since we're talking about PVP, you really need to know, it's like going into Publix and drinking a gallon of bleach. It'll kill you. It's lethal. Everybody, the people you care about, need to understand this is not a drug. It's a synthetic that's being marketed, and we thought we had it off the streets, and it was off the streets for a while. But, you know, this is all lethal. And I don't want you to, I just wanted to share that information.
Yes, ma'am. But I while I was incarcerated, I did the substance abuse
Course.
program, and I completed it.
SAP?
Yes, I did. I did complete
Good for
SAP.
you. Did
Yes,
you,
ma'am.
what, am I saying everything that you learned?
Yes, ma'am. I understand clearly.
I mean,
I understand.
it is,
was-
you know, just so dangerous.
Not to talk about the facts of the case, ma'am. I was just going to the store.
I have no
No.
problem resolving this.
Your Honor, and I'm not making a suggestion one way or the other. I'm just advising you what
Yeah, I
what
hear
happened over
you.
the weekend,
You know,
and
let's not.
just to advise you the allegations. you know.
Yeah, well, he went through SAP, and I think that, you know, in terms of continuing, you know, once you re-enter the community, once you are released back into the community, it's
Ma'am,
really important.
I got a job.
Yeah, I wasn't
lined up.
talking about that. I was talking about you know, you really, really, if you've got an addictive disorder, it's a health issue, and it requires constant treatment so you don't relapse and come back. Because the idea is you don't want to set up this revolving door.
And Your Honor, I have no objection to court resolving it. I just really hope, if the case is resolved, that Mr. O'Neill really does take care of himself. Because I would note the officer mentioned in his report the store that, because it mentions that Mr. O'Neill advised he was coming from a store. The officer did mention that the store that he was coming from on Broward Boulevard, it's known in the area for narcotics distribution at that store. So I just hope he does takes care of himself.
We all do. We all do. I mean, we're a very sophisticated public health culture here in this jurisdiction, and we really, want to be able to give good information, and we really hope, and we know it's challenging, and we know access to care is challenged here, but, BARC is available, and there's faith-based services in the community. And it's just really, really important for people to have good information, about what these risks are, and they're very real. They're very real. So I'll offer you a withhold on the resisting without, and that'll be over.
Yes, ma'am. Thank you.
All right, good lad.
Next we have Larry Mitchell.
Larry Mitchell. Hello.
Good afternoon.
One moment, Your Honor.
Oh, I see that. I see his name. I'm gonna stop it. One second, please.
L'Oreal, could you check in your system? Did the jail receive paperwork? Because I'm showing in BSO pics that on count 3, it was a change of charge from robbery firearm to strong arm robbery. Yeah. So you did receive information that information was filed on that charge. Are you sure it was transferred to a misdemeanor? No. It was changed to a strong arm robbery. Yeah, Your Honor. Okay, so here's what's going on.
Okay.
There are 3 counts before the court. Counts 1 and 2, a filing decision has not been made at this time.
Okay. Count
3, we filed the charge. We downfiled it to strong arm robbery, and we filed it separately under a different case number that has now been created, 18866 CF10A.
Okay.
What I would be requesting,
Does he need to be magistrated on that?
he will, I imagine the clerk's office will process, I don't have any of the paperwork in front of me at the moment, but the clerk will
He'll be
process
back.
it.
He'll be back. So did you get that? Did you hear what's going on?
Can you clarify that for me?
Yeah, can you clarify that?
Yeah, and what I'm gonna, and let me put it this way.
He knows much more than I do.
I'm gonna ask that the court deny the motion because one of the charges was filed. I have no objection to him being ROR'd on counts 1 and 2.
Okay,
Because
tell
we-
me what counts 1 and 2 are.
Each robbery with a firearm.
Okay, robbery with a firearm
Is count one and
is count 1 and count 2.
is robbery firearm.
And there was a motion for ROR pending.
Yes.
And you're indicating that the state has not filed an information.
We filed an information on the third count,
Right, but not on these.
not on those.
Okay, so that'll be granted
So I would ask that the motion be denied since an information was filed.
on number 3.
Yes, but that he would be ROR'd on 1 and 2.
Got it.
And if the court does not mind, if you could put language to clarify, he's being ROR'd on those 2 counts because the state did not file an information on those 2
Where
counts.
is it you'd like me to put that language, other than the record? Okay,
Yeah,
that'll
that's-
work. Thank you.
And I'm sorry, I know the clerk's office prepares orders for this.
Thank
so
you.
That's what I was imagining in my head.
So ROR is hereby granted.
Well, no, I'm asking that it be denied.
On
The
one and-
motion be denied because,
On 1 and 2?
no, just in general, the motion's denied because we did file an information on the third count. But then, language that he's ROR'd on counts 1 and 2.
Shouldn't he be ROR'd
That is really
on this case,
confusing.
1701-4558 CF10A?
Your Honor, my concern is if
Okay,
that
let's-
there's an order RORing him on that, I don't want to see an issue where he gets released from the jail.
But the way I was gonna draft it I thought was actually the clearest way, and I'm not saying it because I'm doing it. I'm simply saying that it reads very clearly, 1 and 2 are granted, 3 denied. And then I can clarify that 3 has been modified.
And I suppose I should be asking the jail, because whatever they tell me is gonna work for them, I'm fine with that. He isn't
No, I totally agree with you. That's how I do it
So
too.
she
I
says
always ask for
granted on
Talia.
This case number, it's not gonna affect the hold on count 3? Okay, so yeah, as long as,
That's
Your
what-
Honor,
mhm.
whatever language you use, as long as you reflect
I'll
he's
t-
only
I
being
promise-
ROR on 1 and 2.
I promise they'll be calling you.
And what is his bond going to be on count 3?
Well,
May I
that's
say
a-
something?
Yeah, as long as you don't talk about facts.
Well, our firearm was a,
Don't talk about anything.
okay.
And as a matter of fact, I wouldn't mind if confinement status would just look at what I do and see if it makes sense, because if it makes sense, then it works.
Well, here's the thing, and Your Honor,
Do you have that newly created case number?
it's 18, oh, yeah.
866?
And Your Honor, the problem with setting a bond, and I wouldn't have an objection to it, the problem with setting a bond on that 1 count is that, and I believe confinement status can confirm this, once the clerk's office processes the change of charge capias,
This is confusing. No, because I think, honestly, they're not going to understand it. I'd have to deny on all. I'd have to grant on all counts and just make a notation as to that a new file was created.
and that's why I was suggesting denying the motion, and despite denying the motion, you're ordering an ROR on the 2 count, on the 2.
They'll never get that. Could I have a new one?
So I'm saying-
So what? You have a new file?
The jail will follow your strict instructions on those 2 counts.
Fine. Okay, then I'll keep what I'm doing.
But he's still entitled to a bond on the
You
strong
didn't
arm
get
robbery.
there yet, counsel. Relax yourself for 1 second. Let me just figure this out. Okay, let's talk about bond.
Your Honor, I wouldn't have a problem with setting a bond on count 3 where,
Where'd he go?
He's speaking to Mr. Reedy, ma'am.
Oh, okay.
Here he comes.
problem is it could be an act of futility, because once the clerk's office processes the new capias that's created from us filing this charge under a new case number, it's gonna go back to no bond hold for magistrates, and they'll still just come back through here.
I understand that.
Yeah, that's the only reason I'm saying why.
But that has to happen.
Yeah, no, I know, I agree.
But I still have to do something. You don't want me to do anything?
No, I'm fine with it. If you want to address the bond now, I'm fine with it. I'm just advising Mr. Reedy. I'm advising
Well, he's
Mr.
entitled
Mitchell.
to-
It could end up, for all I know, tomorrow or the next day, could just again go back to no bond hold for magistrates, and he'll be brought back through first appearances.
But why won't the clerk's office know we set a bond?
They still have to process
The capias.
the capias that's created.
Oh, that is somewhat of a.
But you know what? But I'm aware of this case. If I see him come through, if I'm here, obviously I'll advise the court. And
Okay,
Mr. Reedy, if
is
Mr.
it
Reedy's here.
easier not to address the 18 case than if a new capias is gonna be generated and we hold off on the 18 case and we only focus on the 17?
You know,
I mean, we understand what's gonna be happening, we know a new case is being generated, but maybe then we just focus on the 17 case.
you know what? Actually, the more I think about it, I'm fine with setting a bond only because as of right now, he's being held no bond on a bondable offense.
Yeah, that's my point.
And I'm agreeing. We'll
So
just
if we said, what were you recommending that bond be?
that I don't know. I'd have to pull the. Frankly, I haven't even looked at what the allegations are, and I can do
Because
that.
if he's able to post a bond within the next 10 hours,
Well, and
then he's getting out.
well, he's getting out, but just to advise him, once the capias is created, then there will be. It's there.
That's very messy.
It is, but I off the top of my head right now, and I don't know that any of these things are going to happen. It's just that they could happen, so I just wanted to be aware. But frankly, Judge, I think the best way to proceed, frankly, right now is to set a bond, and whatever happens after that, we'll deal with it as it comes along. But at a minimum, he'll have a bond on a bondable offense.
I just didn't know how much of a bond Mr. Mitchell can afford.
That's a whole nother matter.
Right. Larry, how much bond can you come up with?
It depends on how much it is, Your Honor.
Okay.
Yeah, but I mean, we also have public safety concerns.
Well, I'm going to print out a report for the court and Mr.
So,
Reedy
I mean,
is-
we've got, there's, you know, it's not just about what somebody could afford.
I have a boss that probably can bond me out.
Are you working?
Yes, sir.
What type of work do you do?
I'm, work on boats,
How long have you had that job?
approximately a year and a half,
How long have you been living where you live now?
quite a while, 15, 20 years.
And who do you live with?
My parents.
Your parents know where you are?
Yes, yes, sir.
If you were released or posted bond, would you go back to live with your parents?
Yes. They
Okay.
my mother is 86 and blind. I take care of her. My dad is 80.
You know, I never did see the PCF.
Okay. All right, hang on, Larry.
I wonder if is Rakaya in?
Well, no, because I got to print out the reports. That's just the information.
Hey, how you doing? I know,
explain
long
after.
time no speak. We've missed you. We missed you. Oh, honey, I'm still in magistrates. And we really have a complicating thing that we just don't really know how to treat it. And I was thinking maybe you could give me some input. So we have a defendant on the second look docket, correct? And there's 3 counts, robbery with firearm. And what confinement status in the magistrate courtroom is telling us is that first he is entitled to an ROR on the first 2 counts, but whichever you prefer, the 3rd count has been changed to, what was it changed to? Robbery, no weapon. And here's where the complicating, I think, thing is. A new file has been created. A new case number has been created for this person. It's Larry Mitchell. And the new case number is 18-000-866 CF10A. Sounds like a plan.
Considering they never told you that you know.
Correct. So the question is, what makes the most sense to confinement status, to the process in general? Do I enter an ROR, a granting on everything on the 17 case, and does he come back tomorrow on the 18 case?
He can't come back until you get the KPS from the clerk.
Because doesn't he need to be magistrated on the new charge? Yes.
I've seen it sometimes. I don't know why, but sometimes I've seen 3 weeks back.
Okay, when do you think that happens? When would that happen from your confinement status perspective? Because I think that has a lot to do with just how we all understand the flow of this. Do we have a file? The 18 file? Do we have an 18 file?
Odyssey has. They haven't even created an Odyssey yet. It was literally just filed.
Okay, Rakai is saying that we have to make sure that he's on the magistrate docket tomorrow.
But my understanding is
Okay, Eric's saying something.
that confinement can't put him on the docket until they get the change of charge KPS from the clerk.
And Rakai says that's right.
Okay, so I have no idea when the clerk's gonna process the change of charge KPS.
So how long does that take to get that change of charge KPS?
The best answer I can give you is I've seen sometimes a couple days. I've seen 3 weeks.
Okay, Eric says you can't necessarily know. You can find out and call me back. I have no idea. You know somebody's number? Oh, okay. Okay, beautiful. Thanks. Okay, Rakai is going to find out and call us back. All right,
Okay.
so do you want to pass? Is there anybody
Yeah,
else?
there's one more case left on the
All right,
docket.
we'll be
We can
back
do
with
that.
you on this. Okay, I'm listening. Where do we go?
Carmen Giordino.
Carmen Giordino? Hello.
Hello.
Hello. Yeah.
Are you gonna?
Your Honor.
He's gonna come. We're passing.
He's coming right back.
We're waiting for Rakai. Yeah, Rakayu's gonna call in a couple minutes.
Okay, thank you. I'm sorry.
Okay. Your Honor, information has been filed on Mr. Giordino's case.
Okay, and what is that case?
It is. You mean the case number or the charges?
The charge.
Okay.
Let's wait for Rakayu.
Okay. It was, excuse me, burglary of an occupied dwelling and grand theft.
Okay, so that's been filed, and
Yeah, his bonds were set at $10,000 on count 1, $1,000 on count 2, pretrial release with a GPS level 1, no return to the property.
total bonds 11,000 with pretrial release, GPS monitor, and no return to that property.
Yes, Your Honor.
That's where you're at, in the event that you can bond out. You'd have to report to pretrial release within 24 hours of your release.
Your Honor, it's, because it's a GPS level 1, they would, I don't think they would take care of that before he's.
Oh,
out
they
of
do
custody.
that while he's in custody?
Yeah,
Never
the
mind.
monitor.
They'll do it before you're released. Okay? Do you understand?
Yeah, I'm assuming that I have to bond out to get out? Is that what you're saying?
That's usually how it works.
I didn't know. They said I was
I mean,
going to be released on my own reconnaissance. I was on an ROR
oh.
sheet.
I mean, if we didn't file by today.
Oh, understood. Yes, you're right on that. There was a motion for ROR pending based on the timelines of your detention. And then had the state not filed their information, you would have been entitled to the ROR.
And the jail, I'm seeing the system, the jail has already updated everything, so this is gonna be a situation where I don't believe that he's gonna have to come back, have the bonds reset.
I understood. Okay, but
I
they
just want him
did
to know.
file,
Yeah.
those are the bonds, and this is where you're at.
Okay, and am I entitled to a bond reduction hearing?
You're entitled to a bond reduction hearing before your circuit judge.
Oh, before a circuit judge? Okay.
Right.
Okay, Your Honor.
Good luck.
All right.
Thank you. Okay, well, wait. Yes, thank you. Eric, can you just, that was 10,000 as to count 1?
Yes, and 1,000 on count.
Thank you. Here you go, madam. Nice. Nice. I'm telling you, always go with the client. Do you have any questions?
So she said you can RR count
On
1
it.
and 2.
And what about 3?
3, he'll come back tomorrow, but it should take you today.
It's under a different case number.
We'll bring him back to discuss bond tomorrow.
So as Eric was saying, deny, but RR count 1.
Okay. Well, that's what I did.
That code will work.
All right.
Bye, everybody. See you.
All right. Thank you all. I think, is Mr. Mitchell going to
Hey,
come
Deputy, we
back?
need Mr. Mitchell back. Okay.
So we'll see him tomorrow.
Yeah, well, I just want to explain to him what's going on. Mr. Mitchell, the habeas on the new charge, a third charge, is going to be filed today, and we're going to bring you back tomorrow to discuss conditions of bond. I can't hear you.
So we'll see you tomorrow. Oh, wait, my speaker's up. I'm
Charge?
sorry.
Huh?
Was the third one a lesser charge?
Yes, a much lesser charge.
Much lesser
Okay.
charge, yes.
Okay, so we'll see you tomorrow to talk about bond.
OR,
Yes,
the other, okay.
yeah.
All right, so we'll see you tomorrow.
Okay, and I got a couple of things to say about this probable cause affidavit then too, so.
All
right, we'll see you tomorrow.
Wait with bated breath.
Print out about 40 pages of supplement.
No, don't spoil.
All right.
Don't spoil. That's it. No spoilers.
Okay, we'll see you all tomorrow.
Brian, before you get too married to that, remember, this is a file case. There's about 40 more pages of reports.
really is about the.
All right, Allie.
That's it. You going upstairs? You going out?
I was gonna go see Joe.
Okay, I'm going.
Check back in.
Good night, everybody.
Good night, everybody. We'll see you tomorrow.
It'll be just as much fun then as it was.
Oh, more.